Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. Earlier this year, the Office of the Privacy Commissioner of Canada released a report of findings requiring companies using targeted advertising and offline conversion tracking to revisit and re-examine their privacy practices. But I think the lessons to be learned go beyond the realm of advertising and what's called offline conversion tracking. Really, what is consent under Canada's federal privacy law? Does it have anything to do with what's in your privacy policy? So the Office of the Privacy Commissioner of Canada launched its investigation of a major retailer after receiving a complaint from a customer surprised to discover, upon a review of his Meta Platforms Inc., formerly Facebook account information, that Meta had a record of many of his in-store purchases from a well-known retailer. The retailer confirmed that when in-store customers chose to receive an emailed receipt instead of a paper receipt, it forwarded to Meta the customer's hashed email address and in-store purchase information. For example, date and dollar amount of purchase and general type of purchase such as lumber or hardware. And it did that using Meta's offline conversions tool. Meta, on its end, would then match the hashed email to the customer's Facebook account, if it existed. So if they had a Facebook account, Meta would compare the customer's offline purchase information to the retailer's ads delivered to the customer by Meta to measure the effectiveness of those ads. Now, the email address was hashed so that only when a match was made, the data could be analyzed. If you'd used an email address that was not associated with a Facebook account, nothing happened to the data. It was just deleted. Essentially, the ad platform would know what ads it had shown to logged-in users. With that email address and purchase information, the company could correlate whether the person with that email address had been shown any ads by that advertiser. Meta would provide the results of that analysis back to the retailer in the form of an aggregated report, giving insight into the impact of its advertising on its customers' offline purchasing behavior. Meta would also use the customer's information for its own business purposes, including further targeted advertising. This last point is important because if the recipient of the information is going to use it for their own purposes, it's no longer a transfer for processing, but a full disclosure of personal information under the legislation. So following its investigation into Home Depot of Canada Inc.'s compliance with the Personal Information Protection and Electronic Documents Act, also known as PIPEDA, the OPC decided that organizations can't rely on implied consent obtained via privacy policy for uses and disclosures of customer personal information like this. Now, that finding was even where the information isn't that sensitive in nature. So what does this tell us about consent under PIPEDA more generally? Well, so let's look at what the statute says. The main points of consent are in Principle 3, taken from the Canadian Standards Association Model Code for the Protection of Personal Information. It says, the knowledge and consent of the individual are required for the collection, use, or disclosure of personal information, except where inappropriate. Now, the except where inappropriate part can be completely ignored because the only exceptions to the consent principle are set out in Section 7 of PIPEDA and aren't applicable here. This general principle is elaborated upon in some of the sub-principles. For example, 4.3.2 says, knowledge and consent. Organizations shall make a reasonable effort to ensure that the individual is advised of the purposes for which the information will be used. To make consent meaningful, the purposes must be stated in such a manner that the individual can reasonably understand how the information will be used or disclosed. Sub-principle 4.3.5 then says, in obtaining consent, the reasonable expectations of the individual are also relevant. Section 6.1 of PIPEDA, which was added in 2015, elaborates upon this by creating additional requirements for what is called valid consent. It says, for the purposes of Clause 4.3 of Schedule 1, the consent of an individual is only valid if it is reasonable to expect that an individual to whom the organization's activities are directed would understand the nature, purpose, and consequences of the collection, use, or disclosure of the personal information to which they are consenting. Let's take a step back and think about this. You need consent, and you need it to be valid. Is it reasonable to expect that an individual, particularly at the physical point of sale in a retail establishment, has read the company's privacy policy? Yeah, no, it really isn't. And that's not even taking into account whether the privacy policy or privacy statement clearly explains the nature, purposes, and consequences of the collection, use, and disclosure of personal information. In this case, the Commissioner found that any references to this sort of use were really unclear in the privacy policies or privacy statements. So put yourself in the shoes of someone at the checkout having just paid for their hardware. I've been in that exact position. Would you like your receipt emailed to you? Why, that's great. I lose my paper receipts within minutes, so what a convenience. If you were to ask the typical customer about what is going to happen to their email address, they would say it's going to be used to send them the receipt, just like it says, just like they were asked. At that moment, would the person expect that their email address is also going to be used to track advertising effectiveness? They would say probably not. And the point of sale interface didn't say anything about this practice. All the customer would expect is that the email address would be used to send them a receipt. That's the reasonable expectation of the customer. And by entering their email address, they've consented implicitly to the collection and use of their personal information, namely their email address, for that single purpose, namely to send them the receipt. At this particular retailer, they seem to save the email address, likely associated with the hashed version of the payment card information, to associate a customer with an email address. This is, at least in my experience, since I didn't have to re-enter my email address at checkout when I've opted for a receipt on later purchases. Now, that didn't seem weird to me as a customer, but that may seem unexpected to some. And I would note I've never gotten unsolicited emails from the company, so I don't think they're using the email addresses to send commercial electronic messages. But setting the expectation of the customer is key, along with clearly communicating in the moment how that information is to be used. At least for PIPEDA, that's the requirement. You can't look to your privacy policy to set those expectations unless the customer has just been presented with the policy and has understood it. So that's a pretty clear takeaway from this Privacy Commissioner report of findings. Unfortunately, this is going to get a little bit more confusing under the proposed Consumer Privacy Protection Act. Bill C-27 is currently sitting before the Parliament, and it sets out additional requirements for valid consent, and you'll note that many of these things can't really be done at a physical point of sale, or at least would be difficult. Some of these things are really best left to a privacy policy. It does say you have to advise the individual of the purposes, as does PIPEDA. You have to tell them the manner in which personal information is collected, used, or disclosed. Now, that's probably pretty obvious at a store checkout. The same with paragraph D, since you will be providing the specific type of information at that exact moment. And I'm not sure exactly what they're getting at when they say the consequences in paragraph C, but we'll see how that plays out. And then you have to provide the names of third parties to whom the information may be disclosed, pursuant to paragraph D. It may be that this framework relies on the fact that the new bill permits a lot of collection, use, and disclosure without consent for reasonable business purposes. So a lot of day-to-day personal information handling will be covered under that provision. So section 15 sub 3 is left to those circumstances that doesn't fit within a consent waiver. We'll see. So what's the main takeaway from this finding, at least of general application? First, an organization simply cannot rely on their privacy policy as the foundation for consent in Canada. The purposes have to be communicated to the individual at the time the information is collected. Second, you really have to put yourself in the shoes of the typical customer and think about what would be their reasonable expectation as to how their information is proposed to be used. If it's outside their expectations, you really have to make sure they're aware of it for consent to be valid. And once the CPPA is passed, that will get harder. There's a reason why Home Depot just put an end to the practice during the course of the investigation, since trying to explain offline conversion tracking on a little screen is likely not feasible. I hope this has been interesting and useful. If you've hung around to the end of this, you're clearly interested in this sort of stuff, and you should subscribe. I try to put out a new video every few weeks, so the algorithm will hopefully keep them coming for you. And give it a like, so that more privacy nerds will see it. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.